Hello? Hello, Rhoda. Hello, Faith. How are you? I've now switched over to the phone. I hope you're able to hear me. Just message me on the message app so that I know that you can hear me. Hello, Faith. Hello, Rhoda. How are you? Let me know if you can hear me. All right. Again, my apologies for the breakdown in the communication. I think I have serious connection issues insofar as Wi-Fi is concerned. However, we can pick up from. I guess I would have to start again, hopefully, hoping that members who are online are actually hearing what I am saying. What I was saying was that the Kenya Constitution currently makes provision for what it calls the right to the highest attainable standard of healthcare. The Constitution also says that every person is entitled to the right to reproductive health. In addition to that, the Constitution also guarantees that no person shall be denied emergency medical treatment. So from the outset, it is very clear that health is not just a question of the provision of health services and whatnot. Health is now a question of rights. Health now is a question of rights, and that it is not just rights, but it is a constitutional right. So, which therefore means that there are very serious obligations that are imposed on not just the government, but also other parties who participate in the provision of healthcare services. Now, as I said before, the right to health is guaranteed under Article 43 of the Kenya Constitution. Now, Article 43, unfortunately, is not very clear in terms of the specific obligations on the part of the government. So, what is left is an elaboration of that right through an act of parliament. And last year, in June, the president assented to the piece of legislation that attempts to clarify the specific obligations of the state, attempts to clarify the specific obligations of the county governments insofar as the provision of health services are concerned. And this piece of legislation is what is known as the Health Act. Now, this legislation came into force on the 21st of July 2017. So as we speak, we have a very detailed piece of law that sets out in a very detailed manner in terms. It sets out the obligations of the state. It sets out the obligations of the county government. It sets out the obligations of the various departments of the state. It also sets out the obligations of private healthcare providers insofar as the right to health is concerned. So I'll just run us through the basic provisions, or just a basic framework of this law, and basically just highlight some of those issues that may be of concern to the wider members of the public insofar as the provision of health services is concerned. The first thing that the Act does is that it creates rights and duties of patients, of the government, and of healthcare providers. That is the first thing that it does. The second thing it does is that it clarifies what are the duties and obligations of the national government vis-a-vis the duties and obligations of the county government. Remember that under our current constitutional dispensation, we have what is known as devolved governments. Now, under devolution, the various functions and the various powers have been dispersed to both the national government and the county government. And particularly insofar as the right to health is concerned, or particularly insofar as health is concerned, the main argument is that health has been devolved to the county levels, to the county level governments, with the national government being left with the function of merely providing policy direction. To what extent is this a good thing? To what extent is it a bad thing? We shall see. The third thing that the Act does is that it creates institutions which are responsible for actualizing the various provisions of the Act. And finally, the Act also sets out institutions which regulate the healthcare professionals, they regulate various aspects of the provision of health. And also, very finally, the Act also has various provisions which regulate a lot of other things, which we can mention, for example, things such as health products, things such as public and environmental health, things such as mental health, traditional and alternative medicine, organ and blood donation and transfusion, health financing, the participation of the private participants or private investors insofar as the provision of healthcare is concerned, as well as the conduct of research. What are the rights and the duties that are established under the Act? The first category of rights that the Act deals with are rights that can be claimed by patients, or what the Act calls users, as well as rights that can be claimed by the general public insofar as health is concerned. The first and foremost, and perhaps the most important, is that the Act under Section 5 reiterates that every person has the right to the highest attainable standard of health, which includes reproductive health care, as well as the right to emergency medical treatment. The second right that the Act specifies is what is known as the right to reproductive health care, and that has got a whole list of other claims that citizens may make against the state. And then, more importantly, the Act has what I may call transactional health rights. Now, transactional health rights are the specific claims that an individual can make against a healthcare provider with reference to what may have happened in the course of the provision of some healthcare service of one form or another. The first right that the Act affirms is the right of a person to be treated with their consent. In other words, medical services or any healthcare intervention cannot be done unless the patient has consented to that service, that regimen of treatment, and so on and so forth. So every patient has the right to consent to the treatment that they're being subjected to. And it is not just a question of consent. The Act says that the healthcare provider is under an obligation to inform the patient or the user in terms of to inform the patient or the user in terms of the condition that afflicts them, and also in terms of the treatment regimen that the treatment regimen that exists or is available, as well as informing the user about their right to seek a second opinion, so that a user is not coerced into agreeing to a medical regimen that they don't feel comfortable with or which they know nothing about. The other transactional right that the Act affirms is what is known as the right to confidentiality. As we all know, every patient is entitled to have their confidences respected. I think this is something that flows from even the ethical rules of conduct that govern the practice of medicine. So what the Act simply does is to affirm it, or basically affirm it in terms of legislative provisions, and so on and so forth. But also critically, the Act has done something that is very interesting, that has been something that has actually created a lot of debate. It puts an obligation on the part of employers to create what is known as a lactating station, so that if you're an employer and you have female employees who have children, who are babies actually, young babies, the Act says that you must create a lactating station. And you don't just create a lactating station. The Act also says that you must allow lactating mothers, time to go and breastfeed. So that is now a legal obligation that is set out in the legislation. All right, I basically talked about the regimes, the rights that are created under the Act. However, the Act also has what is known as duties. It doesn't just create rights. As we all know that every right has a corresponding duty to it. So what the Act does is that it has created duties both on the part of users of healthcare services, providers of healthcare services, as well as the government. So that, for example, a user of healthcare service has got the duty to provide accurate information that will enable the provider to give them proper advice in terms of what is afflicting them, and also in terms of the treatment that would be perfect for them under the circumstances. But it also creates a duty on the part of healthcare providers. It says that a healthcare provider has got the duty to provide health services that are requested or that are needed at any given time. And these services must be provided within the context of their professional understanding of what the problem is. But more importantly also, the Act says that healthcare providers, whether they are in the public sector or in the private sector, have the duty to provide emergency medical treatment. And that has been, the issue of emergency medical treatment has been an issue that is it's very thorny in Kenya right now. If some of us followed the story that was in the media sometime back 1 or 2 years ago about a gentleman known as Alex Madaga, who was left to suffer in an ambulance for about 18 hours when the hospitals where he went refused to give him services simply because he could not pay some deposit for admission. And it was a very big issue that went all the way to the courts. Some of the healthcare providers that refused to give him the emergency medical treatment were found to be liable and were fined and or reprimanded. So the question of emergency medical care in Kenya is very significant, and what the Constitution has done is that it has now made it a right, so that the fact that a person is unable to pay some form of deposit when they are coming to hospital as long as they are presenting with an emergency situation, then the healthcare provider is obliged to provide the services that are required. The other critical thing that I want to mention is that the Health Act has apportioned duties between the national government and the county level governments. Now, this is something that draws from the Constitution, which has apportioned those functions in that manner. However, the national government has the obligation simply to create policy, and the county government has the obligation to implement this policy. All right, some slight mishap there. All right, as I was saying the Act actually distributes functions between the national government and the county government. The national government is simply responsible for the implementation of policy, generally speaking. And the county government is supposed to implement policy. However, the question is whether indeed there is a very clear distribution of functions, because one of the things that you will remember is that the... Hello? All right, yeah, it looks like I'm back. I think I'll just have to finish this a bit faster so that we get rid of this, in and out. Okay, so I was saying that you remember that we had very serious problems about a year or so. And actually, even as we speak now, these problems are still continuing. The question of payment of doctors, payment of healthcare providers, payment of nurses, as well as payment of clinical officers. You remember also that we had our doctors who were jailed because they were on strike while they were agitating for their remuneration. Immediately thereafter, the nurses went on strike for almost 150 days. The government did not bother to sort out the strike, I guess because at that time we were in election mode and people were busy looking for votes and so on and so forth. Now the question is, does the law create a mechanism that will allow us to sort out some of these issues when they arise again? Because I can assure you they will arise. As we speak now, there are nurses who have been on strike in certain counties because the money that was promised to them immediately after the last strike, some of these nurses have not been paid, and some of them have actually issued notices or to go on strike, and in fact some of them have actually gone on strike. So the question is, does the legislation create a framework that will prevent this from happening in future? Now, sad news, the legislation is very detailed on a lot of other issues. However, the problem is that it does not create a mechanism that will allow the relevant authorities to deal with the question of strikes. And I think, I don't know whether this is deliberate or it was an oversight or it was simply something that arose out of inability to understand what the issues are. Because what the Act does is that it sort of combines the functions of the national government and the county governments, particularly in terms of the question of the employment of doctors, the question of remuneration of doctors, the question of payment of nurses, the question of payment of clinic officers, and so on and so forth. So as we speak, we don't know who is responsible for employing healthcare professionals. We don't know. The institutions that have been created under the Act are simply responsible for policy. The Act does not specifically state that it is the national government that will employ doctors. It doesn't specify that it is the county governments that will employ doctors. All it does is to say that the institutions, the national government institutions, will be responsible for policy. However, it is hoped that both the national government and the county government can use their consultative mechanisms that have been created under the Constitution and even under the Act to sort out some of these issues. Now, the problem with this makeup is that sometimes, if there is no political goodwill, then a strike would go on and on and on and on in the same way that we saw it happening during the last cycle. So, in terms of whether or not we are going to have strikes that are going to be sorted out immediately, I don't think there is a very clear answer to that issue. The other serious problem that exists in this legislation is that this law has created new institutions, and these institutions are in charge of various aspects of the provision of health. For example, we have institutions which are purportedly responsible for the regulation of healthcare professionals. Now, the problem with that is that the other institutions that existed before this act was passed have not been disbanded. And in fact, it seems like the new institutions have concurrent powers with the institutions that existed before the act was passed. So there's a possibility of conflicts. And one of those areas is the question of the resolution of complaints against healthcare providers. For example, if a patient goes to a hospital and they are not treated properly and they have certain complaints against either the hospital or the provider of the health service, the question that arises is, can they go to the institutions that are created under the new act, or can they go, for example, can they take their complaint, for example, to the Medical Practitioners and Dentists Board? Can they go to the Nursing Council of Kenya? Can they go to the Pharmacy and Poisons Board, and so on and so forth? That position is not very clear. And I can hazard that there'll be serious litigation moving on forward because the law has created what we lawyers call a lacuna. There's a gap. It doesn't give very clear direction in terms of that issue. The other conflict arises from the provisions of the law that seek to regulate medicines. You know, the manufacturing of medicines, the marketing of medicines, the testing of medicines, and so on and so forth. What this act does is that it contemplates the creation of a new body that will be responsible for regulation of the manufacture, marketing, sale, and so on and so forth of drugs. However, at the same time, the Act does not disband what is known as the Pharmacy and Poisons Board. So, which means we will have two bodies with concurrent jurisdiction. Again, that is going to be a very serious problem. And that is going to be a problem because for Kenyans, what we want is access to medicines, particularly when it comes to serious issues such as HIV and AIDS, issues such as tuberculosis, issues such as malaria, matters such as the immunization of children, and so on and so forth. Now, if we have laws that are confusing the legal terrain, then the clashes that are likely to come out in the course of implementation of those laws are likely to affect the supply of these medicines. And we know that these medicines are actually seriously needed in the country. One very final issue, as I'm about to close, is that even though the Act provides for the right to emergency medical treatment, and even though the Act binds even private healthcare providers to provide emergency medical treatment regardless of the ability or inability of a patient to pay. Unfortunately, the Act looks like it creates a burden to private healthcare providers. And already there are issues that are arising. I think there's a possibility that the provisions of the law might be challenged in a court in terms of their constitutionality, in terms of whether or not they violate the right of other participants in the healthcare services to provide healthcare to citizens. For example, the Act says that if someone shows up in a hospital, it doesn't matter whether it is a private hospital or it's a public hospital, with an emergency, that person must be treated. The emergency must be dealt with. Whether or not they're able to pay, that is an issue that has to be raised later and be dealt with. If it turns out that the person cannot pay, then well and good. The Act does not create a mechanism for compensating, whether private or healthcare providers. It does not provide a mechanism for compensating these people or these providers for the services that they would have given to a patient. I think that is a very serious omission that might make the Act unworkable. I think this would be, it's a very brief synopsis of the legislation, and in terms of also a very brief synopsis of the legal framework as it exists in terms of the provision of healthcare services. And I guess the final question would be, so what? Okay, so we have a piece of legislation. It has got all these provisions, it creates certain rights, it creates certain duties, and so on and so forth. So where do we stand? I think the position is that we have a good start. Consider also that the Constitution has created a very firm basis for the provision of healthcare services, and it has said that this is a right. Unlike, I'm sure those of you who are in the United States are aware of the very big debate relating to the Affordable Care Act, or the so-called Obamacare. And I think insofar as Kenya is concerned, I think we are perhaps a step ahead of other jurisdictions in terms of making health a right. So that is a good thing. I think the problem now is, how do we actualize this right? The Health Act is a good start. It is a very, fundamentally, it's a good piece of legislation and so on. But I think there are some weaknesses that have to be tweaked. If we tweak all these weaknesses, if we plug all these holes and so on and so forth, I think we'll be in a position to make even universal healthcare something that is accessible to all Kenyans. And I think that is where we should be going. In fact, the movement now is towards making universal healthcare a right that can be accessed by all Kenyans who are here and perhaps wherever else. Okay, I'm seeing a question by Ladi Abel Micheka. How is the implementation of this act coming along? I think we are now just starting. The institutions that have been created have not even been inaugurated. The act simply spells out the institutions. For example, the Director General of Health has not been appointed. We also have a consultative forum, an intergovernmental consultative forum under the Act. It has not been appointed. We have the Kenya Health Professions Oversight Authority, has not been inaugurated, and so on. So we are still in the baby steps. But I think going forward, there will be movement towards implementing the Act. Do we have the resources to implement the law, or is the same barking dog with no teeth? I think when it comes to resources, it's simply a question of prioritization. What does the state want? What does the government want? Where should we be putting our money? Should we put our money in, for example, buying guns, tanks, tear gas, and so on and so forth? Or should we put our money in the provision of social resources? Remember that healthcare is also one of the pillars of the Vision 2030. And if you heard the president speak the other day after he had been sworn in. Now we are big on this thing that is called the Big Four agenda, and one of the Big Four agendas is health. So if there is political goodwill, then the resources will come in. And we also need to sort out the question of devolution. I think health was devolved too soon, and the national government is also holding on to a lot of resources. Now, if the government can let go of some of these resources, I think they can be deployed in the proper manner. How do the people in diaspora help? I think one of the ways in which the diaspora can help is the creation of forums such as these, where these issues can be discussed. Now, the interesting thing is this, that health is not one of the areas of legal practice that is of priority to lawyers. It is not lucrative. It doesn't bring in the quick cash that most lawyers would want, and therefore not many lawyers are involved in litigation on issues of health. Not many lawyers are involved in even just reading about the question of health and so on and so on. So if we have forums such as this one, then I think that is a good start. But significantly, I think the people who need this information are down there in the grassroots. So I guess the question is, how do we go down to the grassroots and talk to, our villagers, our people in the villages, people in the, in the small rural areas, because they're the guys who are suffering from the lack of provision of health. But as they say, information is power, but people don't have this information. So I guess the question is, how do you get this information to them? Faith is saying it means the government doesn't want to pay the cost. Of course, the government does not want to pay the cost. And I guess it's a question of priorities, as Acheng is suggesting. Where does the government want to put its money, and so on and so forth. So I guess this is it. If there's any questions, I think we can deal with them at the comments level. But I want to thank you for giving me this opportunity to address you on this issue. If you are interested in any further discussion, please get in touch with me, inbox me, and we can pick it up from there. Otherwise, thank you very much. And this is going to be the end of the broadcast.